Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday morning at 10 a.m. Pacific time. Now, for my guests, that's going to be Central Time, I think, right? You're in Louisiana, is that right, Paul?
That's right.
Right, so must be noon there. And we deal with estate planning and trust and estate administration, both from this our own perspective of doing this for ourselves, as well as professionals who are helping clients and friends deal with the myriad issues that come up when we're dealing with the potential transfer of wealth and the actual transfer of wealth. So I'm very pleased to have my guest today, Paul Rabalais. And as we mentioned a minute ago, Paul hails from Louisiana. I think you're my first guest from Louisiana. Spent some memorable time in New Orleans a while back, and I met Paul through an article he wrote not too long ago called "The Six Unique Aspects of Estate Planning in Louisiana." And it caught my eye because, as we've talked about many times on the show, estate law and trust law varies from state to state. There's no overarching national law. And so it's good to be able to get into some of the distinctions there are between the 50 states. And yet at the same time, I think we'll find that although things may be done a little bit differently in Louisiana, by looking at how they're done there, we come up with some good questions to ask our own advisors, whether you're in California like me or you're in North Carolina, Wisconsin, doesn't really matter. So, Paul, thank you very much for coming on Trust and Estates Weekly. Welcome to the show.
Hey, it's excited to be here. I'm excited to share some of our uniqueness that we have here in Louisiana.
That's right. One of the unique things about Louisiana is you have parishes instead of counties. That I know. Aside from that, I don't know. So let's jump right in. The six unique aspects of estate planning, and why don't you, if you want to run through those for us, and then we can go back through each one, or however it makes.
Yeah, sure. I'll just try to run through them fairly quickly, but thorough but brief. So we are different here in Louisiana. I was born and raised in Louisiana, lived here my entire life, except for a year in Boston, Massachusetts, where I earned a master's in tax law from Boston University. So finished that up, came back down here, and have been working in the estate planning field ever since. Most times, when an out-of-state lawyer hears that one of their clients has some issue involving Louisiana, the out-of-state lawyer usually says, I'm not going to touch that with a 10-foot pole. Louisiana's weird and different, and I'm not going there.
Oh,
So, and perhaps, rightfully so, because you used a word that caught my ear a moment ago, myriad. Yeah, not only in each particular state is there a myriad of issues, but when you cross state lines and go state to state, and then you run into a state like Louisiana, which has its traditions based on the French civil law as opposed to the English common law. We have some differences. So let's just jump right in. The first one, and maybe Kevin, you can tell me if you've heard this in other states, is we have something called forced heirship. Even if you, I hate to say it, don't like your child, they may still be what's called a forced heir, and you may not be permitted to disinherit them or leave them nothing. Now, the definition of a forced heir has been watered down over the years, and so now it's really limited to two categories of people. If a parent passes away, if they have a child who is 23 years of age or younger, or if when the parent passes away, they have a child of any age who is incapacitated. Let me just say that they're unable to care for themselves. Then that parent is forced to leave a portion of their estate to that forced heir or to those forced heirs. So, for example, if a parent dies and they have three children and one of them is 22 years old and the other ones are older than 23, they can't have a will or trust that says I'm excluding my 22-year-old. That one forced heir, when there's one, is automatically entitled to 1/4 of the parent's estate. If a parent has two or more forced heirs, then collectively those forced heirs must equally share half of their parent's estate. Now, the forced heirship, it doesn't come up much because it really only comes up when someone has children who are 23 years of age or younger, and they want to just exclude those children. So as you might expect, it may come up from time to time.
Right.
But so it's an issue that we have, and maybe 20 years ago, it was limited to children 23 years of age or younger. Before then, it was all children were forced heirs, and you couldn't exclude any of your children. So that's one. Have you ever heard of that before, Kevin? This forced heirship concept?
Not with respect to children. I've seen it with respect to a spouse, where if a spouse isn't receiving the share that they would get under, under the probate code in a particular state, they can, in essence, impose that on the estate of the decedent, and the court will hear that. But I've never heard that with respect to a child. Now, does this apply only to natural issue, or do adopted children qualify?
Yep.
What is
Adopted children are included in that definition of children. Yeah, sure are. Yeah. So that happens sometimes when an older person adopts someone who's very young, and the older person, for lack of a better term, dies when they're 70 or 75, and they have a 20-year-old child that they adopted, then those forced heirship provisions may apply. So yeah.
I could see it too when you have a second marriage and the new spouse adopts the children who may be
True.
young at the time of the marriage, right? And so now
Yeah.
you have children who are maybe in their teens, and
Yeah. And it sometimes applies when married people just try to leave their estate to their spouse. Then they pass away, they set up their will or trust to leave everything to their spouse, and these forced heirs kind of say, wait a second here, he can't leave everything to his spouse. I'm a forced heir, and I'm entitled to something. So, it does apply in limited circumstances.
So something you said at the very beginning I thought was particularly interesting, and it didn't strike me until you mentioned it, that much of Louisiana's state law comes from French law, whereas like here in California, our estate law is actually a blending of English and Spanish law, right? Because a lot of our law, California was part of Mexico, and prior to that, Spain. And so a lot of our legal tradition comes from Spanish law. And then over time, English common law has kind of gotten layered on top. And for example, Alabama is an English law state. But I forgot, Louisiana has that French heritage, and you can see it existing, to this day in some of these things that you're mentioning. That's
Yeah,
fascinating.
the law really favors the descendants of someone who passed away over the surviving spouse. So I'm not sure if that's part of the French tradition, but we do have this, intestate law and forced heirship law. It's all designed to make sure the children of the decedent are protected, not so much for the surviving spouse.
Right. Interesting. So what's the next one?
The next one is a very unique form of ownership called usufruct. Doesn't exist in any other states, spelled USUFRUCT. Kind of really, as I explain it to people, it kind of means when a married person dies, they often, either through intestate law or through their will, through testate law, they'll often leave their surviving spouse the usufruct of certain assets or of their entire estate to their surviving spouse. And all of the states were common with this concept of a married person leaving their estate in trust for their surviving spouse, often naming the surviving spouse as the trustee, and often naming the children of the deceased spouse as the principal beneficiaries of that trust. This is a little bit like that, but there are some distinctions. So it's embedded in Louisiana because it applies in our intestate law. If a married person dies and the married person owned community property with their spouse and they died intestate, let's say a married couple had $2 million of community property, and let's say the husband dies first, the wife keeps her $1 million. And as to the husband's $1 million, the wife inherits this usufruct until she dies or remarries, whichever occurs first. And when that usufruct terminates, then the assets revert to what's called the naked owners, which would be the children of the husband who passed away. And there's differences on what the usufructuary's rights are, whether they're inheriting the usufruct of what's called a consumable item like cash or a non-consumable item like real estate, homes, or shares of stock. So there's a lot of accounting involved when that usufructuary dies, and similar to a trust arrangement, but very different as well. And most people they see the word, even our great Louisiana residents with their unique accents, that Louisiana residents and out-of-state people have difficulty. I get a kick over how people say the word because again, it's spelled unique, USUFRUCT, and I've heard 150 pronunciations for it. So I get a kick out of that. But yeah, it's very different, but very common in Louisiana. In fact, years ago, one of our Louisiana congressmen put it in the Internal Revenue Code so that in Louisiana, if you give your spouse this lifetime usufruct of your estate, it qualifies for Q-tip treatment. It's written into the Internal Revenue Code, and so it allows for couples in Louisiana who want to take advantage of this usufruct concept. It allows them to do things like qualify for the marital deduction, defer federal estate tax. So it's entrenched in our Louisiana history and in our Louisiana law.
Yeah, interesting. I mean, it's almost like a combination between a life estate and a trust, right? I
I
mean,
was going to mention a life estate, very similar to that as well. So that's another one that where we're different.
and that goes, as I recall, that goes all the way back to biblical uh, strictures about how family members inherit a man who's died. So I think the wife does get the usufruct, but the children then essentially take ownership of the property at the point where the wife dies. So I mean, it depends on where the property came from originally, but if I think it was the husband's originally, that's how it works. So, again, the historic, I did a show a few weeks ago on some of the historic aspects of probate law, but this is really getting into some other very interesting points. So.
Right. Fantastic. Yep. Okay, number three is one I'm gonna. This is not exclusive only to Louisiana. In fact, in California, we both can take advantage of this. We have community property. We're
Right.
one of, I think, we're two of around 9 states that have community property. What what our clients here in Louisiana, and I'm sure what clients in California love, is we have our unique rule of the step up in basis when it relates to community property. Where we get an extra tax benefit is when a married person dies owning community property with their spouse. Some people who aren't really familiar with the concept think, well, certainly the deceased spouse's one half of the community property will get a step up in basis. But no, actually, it's all of the community property. The husband's share and the wife's share get that step up in basis. And speaking of history, Kevin, I was trying to figure out why in the world would Congress give this big tax advantage to only residents of community property states? And I read into it and I realized that, well, a long time ago, most of the assets that were accumulated in the husband's name. And so the husband often died first. And so all of the husband's assets were essentially everything that the married couple owned, because just that's the way it was back in the day. The assets were accumulated in the husband's name. Virtually all of the assets used to get a step up in basis when the husband died anyway, because they were all in his name. So that kind of got us to where we are today. But that's a big benefit that we have in community property states. And it really comes to a surprise to many clients. I'd be anxious to hear about what happens out there in California. Are you seeing the same thing?
Yeah, for sure. For sure. I mean, community property is a big issue here in California. And it comes from the Spanish antecedents of it. And, what it was interesting what you said, because when I was learning about community property, the rationale behind it I was taught was that you had situations where a woman owned property prior to marriage. And you would have kind of the, third or fourth son of an aristocrat who, coming out of England, had virtually no chance that he was going to inherit any of his father's property because of progenitor and, those kind of things. And so they would look to, as they said in the day, marry well, which meant going and finding a woman who had a lot of property who, to marry. And the way the law worked back then was once a man married a woman, he gained management control over her property. And so what unscrupulous men would do is they would get control of the property without ownership and then essentially cheat women out of their property. And so the Spanish didn't want that to happen. They didn't want to have all these women impoverished and taken advantage of. So they developed a different legal tradition that protected women's rights in property so that a husband, even if they got married, he couldn't take away the ownership of the property because any property owned prior to marriage was vested permanently in the wife. So, it basically kept the government from having a lot of, poor women thrown on them as a result of these unscrupulous men. So,
how about that? Good stuff.
yeah, absolutely.
All right, so I'm going to move on to number 4 and dig right into the old probate scene. I've been fortunate to have a lot of conversations with attorneys around the country about their probate system in their state. And I know in California, probate is maybe difficult is the right term, but maybe you'll be able to share more light on that. And in Louisiana, it's fairly streamlined. The parties don't ever have to go to court. Even the attorneys don't have to go to court unless something's contested. So it's mainly, the preparation of documents that get filed at the courthouse, and then they make their way to a judge's office, and a judge signs orders probating the will, letters testamentary, the final judgment. But I've talked to some other lawyers in other states where court appearances are just part of the process. We don't have that here. One thing that I'm interested in talking to you about is, like many states, we have a small, we call it, and that's another distinction in Louisiana. Other states call the process of getting someone's estate settled through the court system probate. We happen to call ours succession. And so we have what we call a small succession affidavit. Applies when someone dies without a will and they had less than $125,000. And every state has their own small estate affidavit rules. But I did read something just in the last couple of days, Kevin, about how the California bill has been proposed to increase the small estate threshold to $750,000.
Oh,
which is a significant change. Just in the last couple of weeks or so, I think that bill was filed in California.
that does sound like how California handles things. I haven't seen anything about that. I'll have to look into that. I know
Yeah.
there is a small estate provision in the probate code here, but
Yeah.
I thought it was.
Yeah. So that to me, that would be a game changer
Yeah.
because while people do have, often have homes that are valuable, and sometimes those homes are in a trust and IRAs and life insurance that pass outside of probate through beneficiary designation. It's going to make it a lot easier for people to take that miscellaneous MetLife stock account that might have $100,000 or $200,000 in value of stock and a few other bank accounts. And I was surprised to see, I don't know if it'll pass, but I was surprised to see even a bill was proposed, because that's a pretty big jump. Most states are in the $50,000, $100,000, $150,000 range for this small estate affidavit, which does permit people, if someone dies and the assets are minimal, it permits that family to avoid the kind of full-blown court and attorney involved probate. So we'll see how it goes, but I see around the country more and more legislatures are are creating legislation enabling things to pass to beneficiaries outside of probate. And whether or not that's a good thing, that remains to be seen. But nonetheless, with POD and TOD and beneficiary designations, some states allow you to title vehicles to pass to a beneficiary when you die. Some states allow you to create your LLC in a way so that the paperwork is done, so that membership interest automatically passes. Some states have TO death, transfer on death deeds for homes and other real estate. So I see a big trend out there where states are trying to carefully enable people to structure what they have in a way so that fewer and fewer things have to go through this kind of court and attorney involved process. What do you think about that, or what are you seeing, Kevin?
So, I mean, here in California, while we can do remote court appearances, like we're, like on a Zoom essentially, you still have to, the attorneys have to appear, the judge is there, all that kind of thing. So it hasn't gotten, to the point where it is in Louisiana. That's for sure. Even when it's not contested, because I'm dealing with a case right now where we're not contested, but I mean, we filed a number of petitions the end of last month, and they're not going to be heard, for example, until the middle of August. And the lawyers have to be there. I'm going to have to appear at least remotely, this kind of thing. So, and I think California is one of the most challenging states for this. One reason is because our property values are so high. Pretty much everybody gets roped into probate unless you create a trust. And even then, I've had cases. This case, actually, the one I'm thinking was not here in California, it was actually in Alabama. But I did have a case where the couple had diligently put all their property into the trust, but still a couple things got left out, and we ended up having to file a probate anyway. So, I do have a friend here in California who's looking for a way to streamline the probate process because it is so costly for a small estate to go through probate here in California because of the length of time. And it seems like every state has a different, I'm sorry, not every state, every, bank has a different form they want filled out, and all. There's
Right.
universality in any of this stuff. And it's really kind of crazy because the reality is every financial institution basically needs the same information. They could come up with a uniform form that could be used for everyone, but they just haven't. And so then for those of us, I'm a professional fiduciary, so I do administration. You have to fill out 10 forms or whatever it is. It becomes very costly. So
Yeah. Yeah. I'm not sure what the solution is, but we'll see. And now we have, technology is being used so much more, and we'll see how that translate both into the estate planning area and the estate administration trust settlement area. So we'll see. But yeah, number 5 here, let me jump in, is it's not a real unique area, but it's unique enough. It's the whole area around using powers of attorney.
mm-hmm.
So, like you were mentioning, it'd be nice if there were kind of customary standard forms that people could use. I know in many states, state legislatures have created statutory powers of attorney. And talking to lawyers in other states, that seems to work pretty well. The financial institutions, the brokerage firms, they're all familiar with the form that the state legislature created or state assembly. And so things work pretty well. But we don't have any of that in Louisiana. Every power of attorney that someone has in Louisiana is unique based on the kind of whims of the attorney who prepared it. So it does create some more challenges when someone tries to use a power of attorney, because every financial institution wants their legal department or their lawyers to review it. And so there's some concerns there. And in Louisiana, we have some unique areas where if your agent or attorney, in fact, wants to do something for what I'll call the principal, that power must be expressly stated in the power of attorney. Things like making gifts, things like handling a probate matter, making healthcare decisions, And there's a few others as well. So we always, and when we review an out-of-state attorney, we look for some of those powers that must be expressly stated in the power of attorney for that agent to have the authority to do things on behalf of the principal. So a little bit unique there. Are you kind of where you are? Do you use more of a statutory?
Well, so in theory, we have certain statutory, abilities, if you will. So one that leaps to mind, because I dealt with this earlier this year, is we have something called a certificate of trust, which by statute, for example, a bank is supposed to accept in lieu of
Sure.
a trust agreement, right? The reality, though, is every single financial institution, escrow, title company has their own form that they want filled out. And even though it has the exact same information on it, if it's not on, their letterhead, they won't take it. So I'm
Yeah.
helping a friend of mine with a situation, and we've done, I think, 5 different certificate of trusts because there was a bank, there was an escrow, there was a title company, and there was a second bank, and it's right there in the statutory language. This is what it needs to have, but I think the lawyers in these institutions want it to be just so, and my feeling is it defeats the purpose of the statute, but it is how it is, right?
Yeah, you're so right about the every institution has their own rules. One quick story is, yeah, my brother-in-law, my sister's husband, was at the Office of Motor Vehicles last week, texting me frantically. His mother had listed his father as the first agent named on the power of attorney, and my brother-in-law, Doug, was listed as the backup. Well, the first named agent had passed away, and my brother-in-law had his death certificate. And so he presents this power of attorney to the Office of Motor Vehicles. He says, here's my mother's power of attorney. She appointed my father first. He's passed away. Here's his death certificate. I'm the backup. And I'd like to get a new title for my mother because she lost it. And they're like, no, we can only work with the first person named. We can't work with an alternate, even if the first person died and you have their death certificate. And then he goes to CarMax to try to sell the vehicle, and they're like, sure, we'll take it, but we have to keep your original document with the original notary seal. So he's like, Paul, what's going on? I talked to 5 different people, I get 5 different answers. So it's frustrating.
Yeah,
Yeah.
yeah.
All right. So let me keep going. Last but not least is, and this one's not real sexy for lack of a better term, but I just wanted to address when I talk about Louisiana, just want to kind of let the public know we don't have any kind of death tax or state inheritance tax or state estate tax. I know a few states do, but we had one, and in 2004, 20 years ago, it got eliminated, and it was a pretty burdensome tax. Every time somebody died, we'd have to make our trip down to the Department of Revenue and pay that tax and get that receipt that the taxes had been paid before a judge would allow the property to be transferred to the survivors. But we just don't have that anymore. We have no death tax like some other states do. So that's number 6.
Yeah. And do you remember what the estate tax rate was before it went away? I'm just
Yeah,
curious.
it was actually an inheritance tax, which was a tax on the recipient of the inheritance. And I do remember that if children were inheriting, their tax rate was 3%. But
Hmm.
if a non-related person was inheriting, their inheritance tax rate was 10%. So it was usually a 3 to 10% tax. And then, of course, if there was a federal estate tax, that also applied.
Right, right. So here in California, actually, we don't have a state estate tax either. But a number of my people that I'm dealing with, we're kind of holding our breaths to see what happens, not so much this year, but next year, as to whether on the federal level, the current regime gets extended. Because if not, especially here in California, a lot more estates are going to get are going to end up having to be liable for estate taxes, because I think the limit returns to what, 4 million or $5 million, something like that. I don't remember exactly the number.
The where the exemption is coming to.
Yeah, where it'll
Is it?
drop to after
Yeah,
20.
it'll drop to it's based on an inflation adjustment factor, but probably around 7 million. It's 5 million adjusted for inflation, but I think it'll be about 7 million.
Okay, so 7 million. Even so, here in California, where like in LA County, the median home price is 900 plus $1,000. So,
Crazy.
if you have other investments, other property, you can hit that $7 million limit pretty quickly.
Yeah.
So, yeah.
Yeah. Hmm.
It's, and the other I'm curious to ask how are you working with your people? This is not Louisiana directed per se,
Yeah.
but given the uncertainty there, how are you talking to your clients about what may happen in roughly a year and a half?
Yeah. It's I don't know if my take on it is unique, but yeah, we have this what is now a $13.6 million exemption scheduled to be around 7 million in 2026. A lot of the public out there is thinking maybe they're thinking something like, okay, I have a $10 million estate, so let me go ahead and gift 1 million or 2 million to that next generation, and that way I can use some of my $13.6 million exemption, and I'll still have $7 million exemption when I die down the road. But that's not the way the law is set up. So when someone dies in 2026 or thereafter, their exemption will be the greater of what was used during their lifetime or the exemption at the time of their death. So the only people really who are kind of benefiting and from this large estate tax exemption that exists this year and next year is if they can kind of afford to make these gifts of $13.6 million and use the large exemption while they have it. Giving away 1 million or 2 million, there's no real significant advantage to that because the exemption in 2026 will still be 7 million and they'll have used 1 or 2 million of it during their lifetime. Um, so I'm having a lot of conversations with people that end up with just, look, there's no need to do anything. You have a $5 million estate, you have a $10 million estate, you're a married couple with a $15 million estate. But really based on the way these sunset rules apply, there's really no need to take action. It's the people who are taking action are those people who can kind of financially swing it and just transfer tens of millions of dollars to the next generation. So we do a lot of education, but winds up, it's really those kind of super wealthy people that will be the ones who will be, attempting to take advantage of this sunset of the Tax Cuts and Jobs Act.
And are you anticipating doing a lot of, follow-up meetings with people come 2026, depending on how things fall out, just to, sort of see at that point then, once presumably at that point we'll know what's going to happen, or how are you?
Yeah. So, and as you know, Kevin, if the exemption is $7 million, and if you're working with a married couple, each spouse has their exemption. So it's really $14 million. So the bulk of the people that I talk to, 90 or 95% of the people, they're just not married couples that have 14 or $15 million or more.
Right.
So for many of the people that I work with, those conversations of okay, now the exemption is 7 million, 14 million for married couples, let's get serious. Those conversations aren't really necessary. But with that certain segment of the population that isn't subject to the estate tax now, but is projected to based on the cutting the exemption in half, yeah, we have to start having some conversations about annual exclusion gifting to children and grandchildren and trying to get some assets out of the estate without using up those exemptions.
Right. And you're really talking about like married couples with, over $14 million. You're thinking that's
Well, over 14, but if a married couple is 60 years old and they have $10 million, they're probably going to live another 20, 25, 30 years. And so the appreciation on that $10 million is likely to wind up to be, 50 or $60 million 30 years from now. So even people under this $14 million married couple threshold ought to at least, be in a position to start making some informed decisions about whether they want to try to structure some things to get things out of the estate and avoid the tax on that future appreciation.
right, right. Well, and as I mentioned at the beginning of the show, I mean, this is something that applies nationwide. This is not
Right.
Louisiana, because this is, we're talking at the federal level. Well, Paul, we're coming up to the end of our time here, but I really appreciate you coming on the show. Uh, Fascinating to both hear how things work in Louisiana, the different language, the different historical tradition, and it is interesting because some of these things I think do play out in other states in other ways. And so it's always good to sort of compare and contrast one state against the other. So thanks so much for coming on the show.
Yeah, and I appreciate the opportunity to be here and really applaud what you're doing. I think us estate lawyers who are in it all day, every day, we like the challenge of just trying to get that education out there so that people can make, informed decisions and don't make mistakes about the things that are most important to them, their family. So I really applaud what you're doing and hope you keep it up.
Thanks very much. I'm going to wrap things up here and then we can talk offline for a minute. So
Okay.
that's our show for today. Thank you very much for tuning in. And let's see, tomorrow, Tuesday at 10 a.m., will be my show, Business Lessons from the Military. So I invite you to tune in. These times are all Pacific time, of course. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. And so again, tune in on Wednesday. And if you have any questions, comments about the show, just look down to the show notes after it posts and you'll see both how to contact me. I'll put Paul's contact information in there, especially if you're in Louisiana and you need some estate work done or estate planning work done. Get in touch with Paul. I'm sure he'll be happy to answer your questions and even more so to help you out. So Paul won't he won't promote himself that way, but I can, shameless promotion, on behalf of my guest. So that wraps it up for today. Again, thank you very much for watching. Signing off as I always do, Marie Darlin, with a guest from nearby where you live, just 2 states over in Alabama. You are my belle. Courage at all times, my friends.